On Wednesday, January 27, 2015, Martin van Breda, his wife Teresa, and their son Rudy were brutally murdered in their home at a luxury Stellenbosch estate. Their daughter Marley survived the attack but sustained serious head injuries. All 4 family members were savagely hacked with an axe. The youngest son Henri survived too, with minimal injuries. In June 2016, Henri was charged with the triple murder of his parents and brother and the attempted murder of his sister. After a lengthy trial, we are days away from hearing his fate. Our legal expert, Tracey Stewart, has been covering the trial for Cape Town, etc. Today, with the guest panelist, Kelly Phelps, we dissect the judgment and the enormous task that sits before Judge Desai. Will he walk free or will he be found guilty?
Today we've got a special guest for you, which we felt was really important to introduce at this stage of our discussions of the case, because we're going to discuss the law and the application of it to all of the evidence that we've heard and know so well so far. So today with us we have Kelly Phelps. Kelly is a lecturer in criminal law at UCT. Hi Kelly.
Hi Tracey.
Welcome,
Thanks.
and thank you for joining us today. The important aspect of this case, which is that it is entirely based on circumstantial evidence. So very briefly, the circumstantial evidence is the fact that Henri was in the house, that he was virtually unharmed compared to his family members, that there was no evidence of an intruder, that there was no evidence of an intruder getting into the estate, that nothing was taken from the home, that the weapons appear to have come from inside the house, blood spatter evidence, as well as the emergency call, the 2-hour, 40-minute period, and what happened during that time, evidence of him trying to aid his family members, the neighbors, evidence of hearing an argument. So there is a lot of circumstantial evidence.
So, given all of the circumstantial evidence that is before Judge Desai, how would you actually go through all of this evidence and figure out that he's guilty or he's not guilty, given that there is only circumstantial evidence?
So it's not really a problem in a case when there's only circumstantial evidence, and equally it doesn't really matter the quantity of circumstantial evidence, but rather the quality of that evidence and the impact that that has on the judge's decision making. So whether it's one piece of circumstantial evidence or whether it's 201 pieces of circumstantial evidence, the same approach applies. The evidence needs to be taken as a whole, and it needs to be consistent with all of the proven facts in the case, and on the basis of that, it needs to be the only reasonable inference that a court can draw based off those proven facts.
One of the things that I always get asked from my followers on Twitter is, what do you think happened? Do you think he did it? And quite simply, the answer to that is what I think is irrelevant. It's what the court decides. I think what we can do is we can maybe debate on what we think has the state discharge that onus of proof, and the issues which we think are going to be the crux of Judge Desai's decision when he makes it on the 21st of May.
The most important piece of evidence from the state's perspective for me is the evidence of self-inflicted injuries. The one piece of evidence that there is no possible other way to construe the existence of this without it meaning that he's guilty. Why would he be self-inflicting injuries unless he was trying to suggest that he had also been attacked, and therefore, to meet the standard of proof, the only reasonable inference would be that he in fact was covering up because he had committed the crime. For me, that is the pivotal piece of evidence for the state. They need the court to accept the proposition that those injuries were self-inflicted. I think without that, the rest of the evidence is not strong enough on balance, in total, to have met their burden. I'm not suggesting that the self-inflicted injuries would decide the case by itself. It would be weighed in the balance with all of the evidence, but I think it's strong enough that it elevates the rest of the state's case. For the defense, they need the judge to engage strongly with their arguments surrounding the question marks with the state's case. So here we're looking at aspects of their argument that there was no DNA for Marley left on the axe, which they're suggesting is a strong indicator that in fact there was another weapon involved, another axe involved that was brought in from the outside, which then supports the defense version, not the state's version. They go through various pieces of evidence like that, including, for example, they argue that the state suggested that it's a security estate that they live in, that the security was impenetrable, that makes it, nearly impossible that it would have been outside intruders. But the defense then put evidence on record that in fact numerous incidences of crime have occurred on that estate. In terms of where those incidences occurred, it wasn't only on the perimeter of the state, it was all over the estate, so that the state simply can't make that contention. So they take all of these arguments and they slowly chip holes at the general foundational premise that the state are trying to make. I think what assists the defense in this regard is the lack of suggested evidence of motive for Henri, or evidence of any kind of propensity that would make it more likely that he could commit such a dramatically heinous crime. And there's also a very strong argument they make in their heads of argument where they claim not only does the physical evidence in this case not support the state's contentions, but it actually supports our contentions more than the state's contentions. That single line will decide whether the judge finds for them that they have done enough to suggest a reasonable possibility. If the judge is swayed by that, it will go for the defense, and if he is more swayed by the balance of the state's narrative propped up by the self-inflicted wounds, he will decide in favor of the state.
A lot of the feedback that I get from my Twitter followers, they generally say, oh, he's going to walk, oh, another South African is going to walk, and we can't convict criminals.
I think it's a really unfair comment, actually. First of all, I think it does a disservice to the state in this case in particular, because I think they have put forward an excellent trial, a very strong case. Reading their legal documents in the case, you can see immediately how well thought through, well presented, well researched their case has been. But a case is only as strong as the evidence that you're presented with. And people go free in many cases for very good reason, and that's because of the burden of proof being on the state. But unless you're a clairvoyant and can see what happened in that room, we are restricted, and a court is certainly restricted, to the evidence available to us. And despite the state's best efforts, they've done an excellent case. This case could result in an acquittal simply because the evidence doesn't match the standard required in order to dispense that burden of proof. In difficult cases like this, it's very important again to remember the practical impact of the burden of proof in a criminal trial. So if the judge and the assessor decide that the evidence in this case is so close that it's really difficult to tell which side it should rest on, in cases of a discrepancy, the burden of proof means that the defense always wins. So how strongly the state have managed to lodge their central evidence on the record will be critical in determining the outcome of this case.
You think that there is enough evidence in his favor?
So Henri doesn't have to prove anything. He has what we call an evidential burden. And the evidential burden means on a practical level, he needs to have provided some basis on which the court can decide that there is a reasonable possibility that his story is true. The courts have been at pains to point out that's not the same thing as saying that a judge has to believe the accused story or that they have to actually think it did happen, but they just need to feel that there's a chance, a reasonable chance that it happened, and you've already then provided that evidential burden and dislodged the state's burden of proof. When you analyze the state's case and the defense's case, you have to apply quite a different approach to analyzing what you perceive to be the strength of their case, because they have very different jobs in front of them, and the job that the state has to perform is a much bigger job than the job that the defense has to perform.
And then, of course, you have quite a strong version from Henri. He took the court into his confidence, he got into the witness box, and his version has not differed from day one much. Obviously he's added a few things here and there, or he's remembered more detail where he perhaps didn't on the first day, but basically from the first police officer who spoke to him, this was his version, which is quite strong. So I think that Judge Desai has, even keeping in mind the legal test that needs to apply when you are looking at circumstantial evidence, and now you also have an accused version, which has been tested and has withstood those tests. It makes it even more difficult for Judge Desai to actually come to a decision whether or not he should convict or acquit. So one of the questions that I have received from a lot of the followers on Twitter is regarding motive. So motive has been mentioned a lot in court, and the general view is that it isn't a legal requirement, but Judge Desai has asked the defense about the motive, and he noted in argument where he said, well, why on earth would two people scale this wall completely undetected, get inside the house and murder this entire family, get out undetected, not remove any of the vehicles, not remove anything from the house? Why would they do that? And one of the answers that the defense gave was, well, there's a lot of fortuitous crime in South Africa, so whether they don't need to have a motive. But then there's also a lot of media coverage on why would Henri do that? So just as why would an intruder do that, the inverse is why would Henri do that? And the state don't seem to have dealt with any reasons why Henri would have done it.
Yes, I actually think this is one of the most interesting parts of this particular case, in the sense that most of the emphasis, both inside and outside of court, has been on the lack of motive for an intruder. So the lack of evidence of an outside party being in the house. Henri, we know, was in the house, was on the scene, and the state have spoken about, and Judge Desai questioned on, or why would someone else have done it? What, they wouldn't have brought their own weapons with them if it was a hit? So there's a lot of emphasis on the lack of motive for someone else. But I actually think this is the weakest part of the state's case, is the question of motive as it pertains to Henri. Now, it's true that in criminal law, motive is not a legal requirement to produce a conviction, but that's not the same thing as saying that it's not important in a trial at all, because motive plays a very important role in terms of the common sense process of reasoning in a court. It essentially provides an air of plausibility to the state's actual evidence, to their surrounding story in the legal case. So, for example, in this case, I think it's a huge question mark as to why the state haven't put forward any kind of motive on the part of Henri. So we've seen a lot of speculation in the media about, so-called alleged drug use and various stories. But if evidence of that actually existed, why has the state not presented that evidence? And when I speak about the practical importance of the question of motive being about an air of plausibility, if you remove the question of motive from Henri in this case, essentially, put simply, the proposition from the state that you're left with is as follows: that a relatively young boy young man in what appears to be a perfectly functional and fairly happy nuclear family unit wakes up the early hours of one morning and decides to brutally bludgeon his entire family to death with an axe for no reason, with no indicator, and with no warning signs. And that is a fundamentally implausible narrative. And then when you consider that the state has the burden of proof, and you've got this kind of implausible narrative, it becomes a much higher leap that you're asking the court to make to decide that, yes, even though there seems to be no apparent reason that this person, who showed no track record or propensity towards any kind of violence in the past and was in a happy family, even though we don't know why, we do know that he definitely bludgeoned them to death with an axe. It makes it quite a difficult case for the state to actually prove in evidential and legal terms.
So one thing's for sure is that after analysing that and hearing those opinions from Kelly, who has really had me in awe all afternoon, that it's a much closer case than what I think most of the general public actually perceive. That it's not a matter of course he did it, and it's not a matter of course he didn't do it. That Judge Desai has an incredibly difficult decision ahead of him, one that I certainly wouldn't want to make. So one thing that we can be sure of is that this will be a high watermark in our criminal justice system. And I'm sure, Kelly, that you'll be talking about this case in years to come, and that either way, there is very, very likely going to be an appeal regardless of this outcome.
Yes, I think a case that is this close in terms of evidence, both in terms of the evidence that has been presented as well as the big gaps in evidence on both sides of this trial, that when you look at how close this case is, it does make it much more likely that one party or the other will most likely appeal, whatever the outcome is.